Yes, Mr. Raj Chaudhary.
May it please your lordship. My lord, as regards item number 12, my lord, this is a Rasoi Private Limited, my lord, company where, my lord, a person who was representing, because Rasoi is the head office in Calcutta, it was having a branch in Guwahati. There was some problem with the Food Adulteration Act. The person who was representing the company over here has expired. So, my lord, I have informed them in Calcutta. So, let it come after 2 weeks, man. Kishan Lal Sharma has.
Mr. P.K. Roy Chaudhary submits that the employer of the petitioner company who was representing the petitioner company in the criminal revision petition has in the meantime expired. Accordingly, he seeks accommodation to obtain instruction from the head office at Calcutta. Prayer is allowed. Relist 4 weeks up is a date. Yes.
27.
22 months, led by Mr. M.K. Chaudhary. He's a guest lecturer today in late June. For some information for the day. The private respondents council.
Mr. P. Bharadwaj, learned counsel for the petitioner, seeks adjournment on the ground that Mr. M.K. Chaudhary, the learned senior counsel who's leading the brief, has some personal he's on leave today due to personal difficulty. With consent, with consent of the other side seeks. Prayer is allowed. Relist.
May I please, your lordship. Lordship, item number 7, lordship. Lordship, today
Yes.
some difficulties, lordship. Can it be after 2 weeks, lordship?
It's a 2012 matter.
Only first week of April, lordship, and others today some
The-
difficulties.
Appellant is on bail.
On bail, lordship. First week of
2012 matter.
April, lordship, and if possible, lordship.
Your name?
F. Hawk, lordship.
F.
Hawk.
Mr. F. Hawk, learned counsel appearing for the appellant, seeks accommodation in the matter. However, since the matter pertains to the year 2012, by way of a last chance, relist on such and such this next week or first Monday.
This one, lordship, after 4 or 5, if possible, 4 or 5, lordship. 4 or 5.
What 4 or 5? May?
No, lordship, April. 8 April, lordship. Obliged, lordship, obliged.
Yes, Mr. Kothari?
May it please your lordship, I beg to mention item 2 of today's daily list.
Yes.
Lordship, my senior is having personal difficulties only for today. If it may be taken up anytime next week, or a date also may be fixed by your lordship.
Senior.
Lordship D.K. Kothari. I am Y. Kothari.
Mr. Y. Kothari, learned counsel for the petitioner on the where is the other side? Have you taken consent?
Lordship, I have not taken consent on the respondent number
wait.
2.
Then you wait.
Yes, lordship. Yes, I did not take consent.
Yes. Call the list.
Item number 1.
Scan copy, he said, na?
May it please your lordship.
Yes.
Lordship, this criminal petition has been filed seeking quashing of
Quashing of FIR or charge sheet?
the FIR and subsequent criminal proceedings.
Proceedings. Where
In
is
the
the FIR?
In the meantime, the parties have already compromised, your lordship, the matter
Compromised.
and amicably settled.
Anything has been filed?
Lordship, additional affidavit I have filed, and an affidavit in opposition is also there
This
on
is
that.
365 and
Lordship,
365.
365.
Where is the FIR? First.
FIR, lordship. Lordship will take up the FIR at page number 13.
Which number?
13, 13.
Yes.
May I read your lordship? My 12-year-old son, namely so-and-so, body color so-and-so, about so-and-so, used to go to work site of carpenter so-and-so every day with a view to learn the work of carpenter assistant. Yesterday, at so-and-so at about 8 a.m., my above said son, with a view to learn work of carpenter out of his workplace and did not return back until night. As he did not return back, I started searching and inquiring for him in the nearby houses and from his friends came to know that the accused number 1 and 2, namely Hajan Bibi and Nizamuddin, kidnapped my son and kept him in country. Actually, this boy had a affair with this lady, your lordship.
IPC to about Dibo, huh? Yes,
This boy had an affair with this lady, your lordship,
which which lady?
with the accused number 1. The allegation is that the boy has been kidnapped by the girl and her brother.
365 full ID of an IPC. Yes, where is the additional affidavit? Which page is the compromise?
Lordship will get it from page number 33.
Is anybody appearing for the complainant here? Has it been compromised?
Yes.
Has been compromised. Yes,
Yes, lordship, page 33 and 36 is the affidavit. Additional affidavit I have brought on record, the affidavit of the complainant and his son, stating that the matter has been amicably settled.
yes,
Page 36, your lordship.
yes.
This affidavit shown by the informant as well as his son.
Nuruddin is the informant
Informant
and Iqbar Hussain.
is the son, your lordship, the victim, alleged victim. Paragraph
And
2,
the
your
additional affidavit is filed by you.
by me to bring on record this affidavit. And they have also filed an, other side has also filed an affidavit in opposition.
Okay then. Heard, Mr.
M.H. Laskar.
M.H. Locker, Learned Counsel for the petitioner. Stop. Also heard, Mr. M. Hussain, Learned Counsel, appearing for the respondent number 2 and 3, stroke informant, stroke victim. And Mr. K.K. Parashar, Learned APP for the state respondent. Stop. By way of this petition,
There is a stay also operating. Criminal proceeding was stayed at that time.
by way of this petition, under section 482 CRPC, read with section 227 of the Constitution of India, comma, the petitioner is seeking quashing of the impugned charge sheet number 313, quashing of the FIR dated 5/8/2013, lodged at Hailakandi Police Station in Hailakandi district and registered as Hailakandi PS case number 290/2013, registered, under section 365/34 IPC, and the impugned charge sheet number 313 dated 30/9/2015, arising out of the aforesaid FIR and subsequent criminal proceedings in connection to GR case number 870/2013, pending before the court of Learned Chief Judicial Magistrate, Hailakandi. Stop. The brief facts of the case is that the victim who is that the respondent number 2 lodged an FIR alleging that it's a complaint or FIR?
Complaint was lodged subsequently, it was lodged as an FIR. The same was lodged as an FIR. Registered as an FIR.
Where do I get the contents of the FIR?
Page 16. The same thing.
No, it's page 16 is in vernacular.
The particular and page 13 is the West.
Alleging that his son, respondent number 2, has been kidnapped by the petitioners. And accordingly, a case was registered under section 365/34 IPC. It appears that after the investigation was completed, charge sheet was submitted by charge sheet number 313/2015. And then what happened before the,
proceeding started. A cognizance was taken.
which page?
Lordship will get at page number 30.
13,
30. Even NBWA issued
30.
30. The order of the learned court below, your lordship.
And thereafter, the learned Chief Judicial Magistrate Hailakandi proceeded with the case, correct?
Lordship.
Proceeded with the case. Against the aforesaid FIR and the further criminal, against the FIR, against the aforesaid FIR and the subsequent charge sheet and the criminal proceedings, the present criminal petition has been filed. Mr. So-and-so learned counsel for the petitioner submits that the petitioner number, petitioner had a love affair with the respondent number 2,
3.
respondent
the
number 3, and the respondent number 3 had voluntarily gone to the house of the petitioner. However, due to misunderstanding, the respondent number 2, who is the father of the respondent number 3, lodged the FIR. He further submits that upon the misunderstanding being clarified, the respondent number 2 and respondent number 3 has sworn an affidavit before the notary officer, wherein they have clearly admitted that the FIR was lodged out of misunderstanding and that the matter has now been amicably settled between the parties. He accordingly submits that in view of the aforesaid compromise, further criminal proceeding and the criminal proceeding against the petitioner is not justified. Per contra, don't say per contra. Mr. Your name? Mr. Am Hussain, learned counsel, appearing for the respondent number 2 and 3, concedes the aforesaid submission of Mr. So-and-so, learned counsel for the petitioner, and further submits that it was out of that due to the love affair between the respondent number 3 and the petitioner,
Number 1. Petitioner number 1.
And the petitioner number 1, the respondent number 3 had fled with her. And as such, and after the misunderstanding was over, the respondent number 2, stroke complainant, stroke father, has has compromised the matter with the petitioner number 1. Stop. With the petitioners. Stop. Heard, perused. apt to reproduce the affidavit filed by the respondent number 2 and 3 before the sworn before the notary officer, which is enclosed as Annexure A to the additional affidavit filed on behalf of the petitioners on 30/8 to 2025. Stop. Operating portion of the affidavit relevant which is reproduced very quickly. It is reproduced here under for ready reference. A to A, page 36. Perusal of the aforesaid affidavit, it is crystal clear that due to misunderstanding, the respondent number 2 had lodged the FIR, and after the misunderstanding was cleared, he had compromised the matter and has stated in the oath that he has no objection if the FIR and subsequent criminal proceedings arising thereof is quashed. Stop. In view of the above, in the interest of justice, for the continuation of criminal proceeding against the petitioners is not justified. Accordingly, the FIR dated 5/8/2013, charge sheet dated 30/9/2015, and subsequent criminal proceedings in GR case number 870/2013 arising out of Hailakandi PS case number 290/2013 pending in the court of learned CJM Hailakandi against the petitioner stands set aside and quashed. Interim order passed. Passed by this court by order dated 15/5/2017, resultantly, so and so becomes, is made hereby absolute, disposed of.
Obliged.
Yes, where is Mr. Kothari? You found your counterpart.
Lordship.
Any objection? They want accommodation today. Heard Mr. DK, I've heard Mr. Y. Kothari, learned counsel for the petitioner. Also heard Mr. PP Datta, learned counsel appearing for the respondent number 2, and KK Parashar, learned APP for the state respondent. Stop. Mr. Y. Kothari, learned counsel for the petitioner, seeks accommodation for
As per Lordship, only for today.
accommodation for the day on the ground that Mr. DK Kothari, learned counsel, who is conducting the who is arguing the brief, is having personal
Personal
difficulties. Prayer is not opposed, released. When?
Deeply obliged.
Yes, Mr. Munir.
Well, here the case diary was called for, my lord. Yes, with the availability.
Yes, there he has come.
Hello.
But I think I had heard this matter for
Yes.
some time. What was it? Refresh, I have forgotten.
Well, here the petitioner number 1, he purchased a plot of land, madam. And subsequently, as the land was, there was co-partners, there was a requirement for submitting the NOC by the other co-partners. Now, it is the allegation that NOC.
Signature, dead person.
Yes, that person has signed it. That.
Yes.
First of all, FIR, my lord, dated is on 2/8/2019.
Huh?
FIR dated 2/8/2019. And this court, file order dated, my lord,
1980.
19/8/2019, has been stayed. Only few days, my lord, got the to investigate the matter. Now, before filing its FIR, my lord, the informant obtained some RTI information. RTI were seized, Jamabandi and all these were available in that. After that only, that FIR has been lodged. Now, though these documents were seized, the investigation is in
Stayed.
the initial stage, when this already stayed. Now, yes, madam, maybe documentary evidence. I will have to come to a conclusion. Otherwise, dear bail, maybe, madam.
No, this is not a case of bail.
No, I'm saying, madam. It's a bail, not a thing. Madam. But why this proceeding has to be stayed, madam, or has to be quashed, madam?
That is why I was ready
Let
to
the-
dismiss this criminal petition on the other day,
Madam,
if I'm not
Ma'am,
wrong,
ma'am.
correct? But I was pointed out by that earlier there is an order calling for the case diary. That's how
Yes.
I had
case
to,
that I have done.
I had, no, but so case diary indicates that investigation within 2 weeks they have filed. So that investigation basically did not proceed.
Yes.
Mr. Munir, sorry,
Nice.
this is not
If
a
there
case
are no
for.
statements, my lord, then I can, if there are no statements, if investigation has not,
You see, this
No, no,
investigation
yes.
is not complete, Mr. Munir.
some statements are there.
Statements of some witnesses
That
there.
could be whether those statements have,
And-
at this stage, you see, Mr. Munir, investigation is not completed. Right?
True.
Suppose from the materials collected and after collecting all the statements, nothing comes out. You have you can be discharged.
And-
You can apply for that.
In,
And who knows, maybe the investigating officer may not file a charge sheet against you. He may
Madam,
file an
True.
FR.
in.
But it is at the stage where nothing has, you see, it's a matter of 2019.
19 and state madam.
It appears it is an abuse of court process because as I have pointed out, on the face of the FIR, there is allegation. Whether that allegation is correct, not correct, how can this court look into it at this moment? Isn't it?
If there are no
And
statements,
you
my lord,
have
I can-
obtained a stay.
And
And this entire proceeding appears to have been stayed since 2019. We are in 25 now,
in this,
6 years.
in this situation, well,
Before the FIR, my lord, the report from the RTI obtained. As for the report, Jamabandi in the name of what they have said in the complainant, name of the just person, Anupama
The
Borgohain.
persons who are dead.
My lord.
Huh?
Kankal Bakal.
And that person I have nothing, but Anupama
Is in the
Gohain-
name of whom?
Anupama Gohain is there.
Land is in the name of Anupama.
Anupama is,
She is the seller.
she is,
But
she's
so far
the
investigation was-
alleged seller or
My lord?
she's the alleged seller?
Yes,
Alleged seller.
yes.
And proper investigation at that point of.
No,
time
but,
was-
The
Yeah.
land was in her name. She sold it to the petitioner number 1. So in this situation,
She sold it to petitioner number
petitioner number 1.
and you are the petitioner.
And
But what about the seller? You have not gone after the seller. There is
The-
no the
No,
FIR.
no, again, nothing against the seller. It is the seller who
If-
have manufactured that document.
Mr. Parashar, if he has bought this land and the land stands in the name of the person whose name is recorded in the rights,
Jamabandi,
record
yes.
of rights, then how a case is maintainable against this person? He is a purchaser.
I'm the purchaser.
There are 3% purchases so far, Anupama Gohain.
Are you following what I am asking? Where is the FIR?
FIR, my lord will find. Page 35. ma'am. It starts from 34, operating part 35.
So accused 1 and 2 is you,
Yes, ma'am, I'm representing.
1 and 2.
Yes.
But who are the other accused?
Other accused are officers of the sub-register.
You are appearing for 1 and 2?
I'm appearing for, except accused number 6, I'm appearing for the rest, my lord. For accused
are
number,
they? 6 is the Mondal. And who are these?
third, second is, my lord,
Number 1 is who?
the purchaser.
Number 2?
It is alleged that number two has forged this sign,
Who
And-
is he otherwise?
my lord.
Who is he? Is the
No,
seller?
no, not the seller.
And who is number three?
Number three is the son of number two. Number four is a business person, my lord, businessman.
What is the allegation against him?
It is the allegation that one and two have purchased the land in connivance with 327.
3 to 7.
That is the allegation. And 327 are, my lord, retired employee of the register, then LR and Mondal. That document was submitted by the seller. And this,
Now this Anupama Gohai is it had died,
no,
is it?
no, she did not die.
Huh?
Kankal Bakal. He died in,
And out of the three, one has died. So signatures have been forged.
There has to be a certain mallet.
All right, all right.
well, in this situation, well,
All right.
in this situation, if I may pray, my lord.
Mr. Munir, if nothing comes out,
Yes, yes, yes.
you can always be
Yes, yes.
discharged. or-
I'm not
At
against
this
the.
stage, I'm not.
My lord, man.
uh,
I'm with your lordship, my lord. Let the investigation go on, my lord. We don't have any objection, my lord. In this situation, my lord, as it is apparent, my lord, all these are documentary evidence, my lord, and this petitioner, there may not be any, because their custodial interrogation is not
You
required.
have filed a bail application,
No, my lord, this is 482.
then
Then, my lord,
Before
my
the
lord,
application-
my lord may pass an order that no coercive action may be
hold
taken.
on.
That.
Mr. Munir, I
yes.
am not giving any such orders. This is a criminal petition, and in criminal petition, I find that there is no case for quashing. I'm simply dismissing your case by quashing it. No further, nothing like a no coercive steps and all. That you are entitled to file, correct, you are entitled to file an application for bail. Sorry, if you want, I'm going to impose cost also now. Otherwise, because I find that for 6 years, the criminal case has been kept pending. It looks like the intention is not bona fide. For 6 years, this
There
matter.
has to be some attempt on the part of the respondent also to
No,
bring it on,
sorry,
to bring
Mr.
it
Munir.
to be listed, my lord.
Yes, please take it down. Heard Mr. K. Munir, Learned Counsel, K. Munir,
PK.
P.K. Munir, Learned Counsel appearing for the petitioner. Top. Also heard Mr. K.K. Parashar, Learned APP for the state respondent, and Mr. B.K. Gogoi, Learned Counsel appearing for the respondent number 2 and 3. Stop.
There are two petition lordship and 4, item number 4, I am.
Uh, তুমি দুটা একেলগে দিবা তো ওপৰতে PK Munir in criminal petition 944/2019 তাতে লগাই দিবা, and Mr. D. Mohanta, Learned Counsel for the petitioner in criminal petition 1461 of 2019. Your same, the arraignment of respondent is same in both. Both the criminal petition having arisen out of the same FIR, is taken up for final disposal at the admission stage by this common judgment and order. Stop. This petition is filed under section 482 of the CRPC 1973 for quashing of the first information report registered as Dhemaji Police Station case number 305 of 2019 under sections 120B, 419, 420, 468, 471 IPC within bracket corresponding GR case number 786/2019 within bracket BNJ. I don't have to mention the complaint case, subsequent FIR only. The facts of the case is that
I'm also told by my friend, my lord, that complaint, my lord, has been withdrawn. I'm been told my friend.
where is the FIR?
FI 34, my lord.
Is that the respondent number 23 comma stroke complainant has lodged an FIR dated 2/8/2019 before the jurisdictional police station alleging that the accused number 1 stroke petitioner in criminal petition 944 of 2019 had purchased a plot of land measuring 1 bigha of first-class Bosti land under block number 2 of Dhemaji Nagar, covered by DAG number 45 of periodic Patta number 35 by fraudulent means and conspiracy. It is further alleged that the said land is mutated in the names of the grandfather of the respondent number 2 and of the respondent number 2 and 3, i.e. late Bhadreshwar Chumwa, comma, late Tanka Bakal, and 1 Anupama Gohai. It is further alleged that the accused number 1 and 2 within bracket likhitiba petitioner number 1 and 2
1 and 2.
in criminal petition 944 of 2019 in connivance with accused number 3 to 7 within bracket accused number 3, 4, 5, 7 7 being the petitioner number 3, 4, 5, 6, 7
Yes.
in criminal petition 944 of 2019 and accused number 6 stroke petitioner in criminal petition 1461 of 2019 with the aid of administrative machinery for personal gain along with the officers of Circle Office, Deputy Registrar, Revenue Branch of Deputy Commissioner's Office, Dhemaji, had forged the land documents and registered the deed, thereby registered the deed. Stop. It is further alleged that from the RTI reply, it has come out that
Father of witness, informant number 2, man.
that is who? That is Tonka Bakal.
Yes, madam.
That late Tonka Bakal died on 23/10/1987. However, he has been shown alive on the affidavit dated 15/7/2014. Which is this affidavit? Affidavit is the sale deed.
No, my lord. NOC. It's
Being
on
the
record, sir.
alleged NOC. Being the alleged NOC
NOC.
for this sale transaction in question. Correct?
Yes, ma'am.
Stop. Accordingly, a case has been registered under section sections 120B, 419, 420, 468, 471 of IPC. Now, pertinent that prior to filing the instant said FIR, the the respondent number 2 and 3 had earlier filed a complaint under section 420 stroke 468 stroke 471 stroke 34 of IPC on 7/9/2018 before the court of Chief Judicial Magistrate Dhemaji, which was registered as complaint case CR number case 182 stroke 2018. However, the said complaint case was not proceeded and later on the FIR was filed.
That was withdrawn, madam.
Today, it is in fact submitted at the bar that the said complaint case was also withdrawn by the respondent number 2 and 3. Stop. After the FIR was filed, what happened? You have received a notice to appear.
41A notice was served on me, madam.
After the registration of the instant FIR, comma, where is that notice?
At 43, madam.
Notices under section 41A
Yes.
CRPC have been issued to the petitioners for appearing before the jurisdictional investigating officer.
Yes.
At this stage, the instant criminal petition has been filed seeking quashing of the FIR and the said notice. Notice or date to that notice to date note 6/8/19. Only one notice you have annexed.
Madam.
And who is this Ramon?
He's the petitioner number 5, madam.
Others have not received notice.
They were not, at that time, they did not receive, madam. Only he.
Petitioner number 5.
5.
Petition number 5. A notice are dated to 6/8/2019. Okay, any confusion? Okay. And where is the stay order?
It is 19/8/2019, madam.
Wherein this court by order dated 19/8/2019 was pleased to stay the investigation in connection with the said FIR till the returnable date and the said which was continued till date, which thereafter was continued till date. Stop. Mr. Munir, so and so learned counsel for the petitioner submits, Mr. Munir, learned counsel for the petitioner in CR petition 944 of 2019 submits that the petitioner number 1 and 2 are the purchaser.
Only one is the
Petitioner number 1 is the purchaser of the subject lent and the lent being in the name of one Anupama.
Anupama Gohain.
Anupama
Gohain.
Gohain, na?
Gohain.
Gohain.
Anupama Gohain. Gohain.
Gohain. No criminal action can be brought out against him, right? He further submits that in good faith he had purchased the land from the said Anupama Gohain. He further submits that Anupama Gohain is not named as an accused in the
FIR.
FIR. He further submits that no criminal case is made out on the face of the FIR, and therefore the criminal proceedings against the petitioners are not justified. Correct? These are your submissions. He further submits that the rest of the petitioners, being officers of the revenue circle, jurisdictional revenue circle,
Revenue.
are also
Sub-register office
officers of the jurisdictional sub-registrar
and revenue.
and revenue circle, has nothing to do with the allegation brought out in the FIR, and therefore no cases made out, no criminal cases also made out against them. Mr. Mohanta, learned counsel appearing for the petitioner in criminal petition 1461 of 2019, submits that the petitioner is the Mondal of the jurisdictional Mondal, and has nothing to do in the alleged sale transaction, and therefore therefore no criminal case is liable, warrants to be continued against the said petitioner. Stop. Per contra, Mr. Parashar so-and-so, learned APP for the state respondent, submits that the scanned copy of the case diary called for by this court earlier by order dated 8/11/2024 indicates that the investigation is at a very investigation virtually did not start as within
2 weeks, madam.
as within 2 weeks the petitioners had obtained stay of the investigation from this court. He further submits that the RTI report available in the case diary indicates the length is recorded in the name of Anupam
Upama Gohain.
Gohai before the revenue circle. Stop. He further submits that since the investigation investigation is yet to be completed and is at a crucial stage, the FIR in question ought not be quashed inasmuch as the allegation set out in the FIR clearly makes out a criminal case against the petitioners. Stop. Correct. And
Original case diary,
scan copy of the case diary.
scan copy, not a scan copy, original citizen.
Okay, original case. Then remove the word scan copy,
Scan copy.
just case diary. Mr. BK Gogoi. Mr. BK Gogoi, learned counsel appearing for the respondent number 2 and 3, submits that the allegations submits that the offense is serious in nature, and the allegation clearly makes out criminal offense, clearly makes out the offense under which the FIR has been registered, and accordingly submits that no case for quashing of the FIR at this stage is made out. He further submits that in the event no materials is collected by the investigating officer, no, don't say all that. Stop. That's all. I have given my prudent considerations to the learned counsel, to the arguments advanced by the learned counsels for all the parties, for all the contending parties, and have perused the materials available on record, including the case diary produced before this court. I have, stop. Apt to reproduce the affidavits sorry, the FIR at the outset, quote unquote, page 34 to 36. Reading of the instant FIR, it is apparent that the that it is apparent that it is alleged that the petitioner number 2 and 3, in connivance with the remaining petitioners, who are the officers of the circle officer, deputy registrar, revenue branch of deputy commissioner's office, Dhemaji,
1 and 2. It is 1 and 2.
had forged the land documents and registered the deed in question.
Yes.
It further appears that on the basis of such forged sale deed, petitioner number 1 had purchased the subject land. It further appears that the said land, which was in the names of the grandfathers of the respondent number 2, I late Bhadreshwar Chamua, late Tonka Bakal,
Yes.
and one Anupama Gohai, has been shown to have sold to the petitioner number 1.
Well,
It is further alleged that on the date of the sale transaction, it is apparent that Tonka Bakal was not alive, as he died on 23/10/1987. It is accordingly alleged that the aforesaid signature apparently is forged by the petitioner number 1, along with the help of petitioner number other petitioners, stroke co-accused. A careful examination of the aforesaid averments, appear that if the said averments are taken on the face value to be correct, criminal offense is clearly made out. That being so, this court, while exercising the jurisdiction of quashing the FIR, cannot look into the merits of these allegations, and therefore, by applying the test laid down by the apex court in the case of Bhajanlal versus State of Punjab, reported in so and so, is of the unhesitant view that on the face of the FIR, unhesitant view that the investigation being at the initial stage, quashing of the FIR would be wholly unjustified. Stop. I've kept it like this. I have not said it, otherwise it might prejudice you. So I've just kept it like this. Having held so, this criminal petitions fails with the aforesaid observations of dismissed. Sorry, Mr. Munir.
oh, very well.
For orders, item number 5.
3 and 4, as in, no? Yes, why is this matter for orders?
Orders, my lord, there was some mistake on my part, my lord.
Huh?
Last affidavit, my lord, on 19 December, I need to file charge sheet, my lord. Because the other side is not appearing, then I made a prayer to stay the proceeding, my lord, then she will come. But unfortunately, I filed only orders, my lord.
So you do whatever has to be done.
Yes, my
You
lord,
file it.
some time be granted to me.
Mr. J.J. Borbhuyan.
J.I. J.I.
J.I. Borbhuyan, learned counsel for the petitioner submits submits that due to oversight, he could not bring the charge sheet in question, charge sheet on the subject charge sheet on record, and accordingly seeks some accommodation in the matter. Prayer is allowed. Released. When?
After Bihu vacation, my lord.
Give a date. Yes.
24.
Oh,
For hearing item number 6.
Lordship, before starting Lordship hearing matters, I have item at 25. Yesterday I took consent also, but I missed the mention time due to traffic congestion, Lordship.
You missed the bus.
My Lordship, I apologize, Lordship, for out of time.
Acha, this already advanced circulation was
Lordship,
given.
yes.
Okay, I'm making an exception today, but next time when you
Sorry, I
miss the
apologize,
bus, I'm
Lordship.
not going to accommodate you.
My apology, Lordship.
Mr.
PP Datta.
P.P. Datta, learned counsel appearing for the respondent with consent from the learned counsel appearing for the appellant by circulating advance adjournment notice seeks
2 weeks time.
2 weeks time, six adjournment of the appeal for a period of 2 weeks. Prayer is allowed, released after 2 weeks on a date to be fixed by the registry.
Obliged, Lordship.
May I please, your lordship?
Yes,
In this case, my lord, I have withdrawn and I have sent him letter and that
you
letter-
have withdrawn.
Yes, my lord. I have intimated him and that has been received by him.
So we'll appoint someone,
My lord.
amicus. Mr. Fukan, would you like to assist this case in this matter? As an amicus curiae, item number 6, the criminal appeal. Item number 6.
S. Sahu.
S.
Sahu.
Mr. S. Sahu, learned counsel appearing for the appellant, submits that, where is the letter?
My lord, I have,
Submits that due to personal difficulty.
my lord, I have intimated him, but he did
No,
not.
no, you are withdrawing it. Why?
Because, my lord, I tried to contact him.
Due to personal difficulty, has withdrawn himself for has withdrawn his engagement as counsel in the instant appeal, and accordingly has intimated the appellant by letter dated 19/7/2024, which appears to have been received when,
My lord,
which is the column?
my
Delivered,
lord, on 13/8/2024.
which appears to have been delivered to the appellant on 13/8/2024 as per the track consignment report issued from submitted. Stop. Copies of the letter dated 19/7/2024 and track consignment. This is called what? Track consignment report.
Track consignment.
Track
Yes, ma'am.
consignment report placed before this court is kept on record and marked as X and Y. Eto mark kore dibo. It appears that this appeal is pending since 2012, and since today when the matter has been filed, there has been no alternative arrangement on behalf of the appellant, keeping the interest of the appellant, this court appoints Mr. R.B. Fukan, learned counsel, to represent the appellant as an amicus curiae in the appeal. Let registry, paper book is made,
Not my lord.
not required. Let registry furnish the copy of the appeal memo along with all the relevant documents to Mr. R.B. Fukan, learned amicus curiae. You want to say something?
Relevant document, statement of the,
Relevant documents. Let registry reflect the name of Mr. R.B. Fukan, Leonard Amicus Curie in the cause list. Yes, when do you want it?
I'm not available on Tuesday. If it is not inconvenience,
No, I think after Bihu because
after Bihu vacation, I'll
you
be
have a
good.
look
Yes,
at the
yes.
papers.
absolutely no problem.
I
I thought there's an
list
urgency. I didn't know.
for hearing on such and such date.
Great.
Number 9.
Yes. None appears for the petitioner when called. Mr. So and so and Mr. P. Thakur Leonard, you're also appearing. Huh? So and so for the state respondent, huh? APP. Should I list this on Friday? Should I list this on Monday for dismissal? Huh? Huh? Revision petition. In view of no representation on behalf of the but this appears this matter was last listed in 2012. This is simply like a relist date the doc next week on such and such date. Let registry since this matter was last listed on 27/7/2012. Let registry intimate the next date of listing to the learned counsel appearing on behalf of the petitioner.
Number 10.
Yes, Mr. Holloway, I believe because of his recent engagement in the directorate, perhaps will not be able to appear in this matter. So, when? Why 3 weeks? CBI has to make necessary alternative arrangements. It's 12 matter. Matter cannot be kept. For today, there is no difficulty. I shall accommodate, but you inform the CBI authorities to make alternative arrangements.
No, sir, my lord.
Heard, Mr.
Jai Islam.
J. Islam and MS. He's for the petitioner and T. Begum for respondent. MS T. Begum, Learned Counsel submits that that Mr. M. Holloway, who is the special PP for CBI, is will not be able to appear in the instant revision petition due to his recent appointment as deputy director, as assistant director, deputy director of prosecution in the state government, right? Stop. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
May I please your lordship may kindly pass over for time being.
Why?
Your Lordship, my senior is on leg in another court, Your Lordship.
Who's your senior?
BK Sen.
How colorful.
Much obliged.
Yeah, please, Your Lordship. In
Yes.
this matter, I have lost the contact with the petitioner. I have lost the contact with the petitioner. Lordship. I have sent a letter.
But what contact you need?
And it
The
has been
revision-
returned
It's a
with
criminal petition.
criminal petition, Lord. And it has been returned that on the next page, Lordship, item returned at the addressee left without instruction. In fact, I have sent this notice through WhatsApp also, and he has received it.
What
seeing-
is, but you have challenged the charge sheet and complaint case,
Lordship,
42417.
Lordship.
Let us see if a case is made out or not.
It was a matter regarding some contractual liabilities. And the notice was also served upon the respondent, but he also did not appear.
Let us see. If suppose this is a purely civil dispute,
Lordship,
then I will quash it. Because you don't need any instruction.
Lordship.
Why to keep this 2012 matter pending? Where is the FIR?
Complaint is at page 13.
Yes, please read.
It was lodged by Safiul Mandal against the accused Ranadhir Sharma.
Para 3,
I'm reading at page 13. It starts and
that is not required. Para 3, page 14. Start.
page 40. Yes. The accused received two contracts of BZR oil refinery bearing tender number so and so, whose total value is 4,27,500 and tender number so and so, whose total value is 1,58,815 respectively. After getting the above mentioned two contracts, the accused has
You are D. Chaudhary, na?
yes.
So your name is there on record.
Lordship. Has subcontracted the above contract to the complainant, and in respect of that, on last 11/10/2010, the deed of contract has been executed between the complainant and the accused, and on 17/10/2010, the accused has given power of attorney to the complainant. Paragraph number 5. Though the complainant executed the aforesaid two works by spending money from his own pocket, the accused did not open a joint account as per the terms of the contract and instead received the running bill, and the accused tried to misappropriate the same behind the back of the complainant.
This is a purely civil dispute.
Lordship,
Yes, how?
that was my case.
So I will quash it or I will give you some time. But same FIR, there are 3 cases.
No, not
Which
three.
is, 13.
13.
13. Heard Mr. D. Chaudhary, learned counsel for the appellant, petitioner. Top also heard Mr. P. Bhattakur, learned APP for the state respondent. None appears for the respondent number
2.
Respondent number 2 complaint, despite the name of the learned
The presumption has been drawn against him. 2/3/2015. There is an order.
Stop, huh? It appears that, where page?
2/3/2015 order is there regarding presumption.
2, 3.
2015.
By the office
Lordship,
or the court?
I think by the court, Lordship.
Okay. It appears that this court by order dated 2/3/2015 has declared that has held that notice has been duly served on the respondent number 2, as the office has reported that on 24/11/2014 the AD card has been received. Since, however, despite of receipt of notice, respondent number 2 chose not to appear before this court till date. Stop. This matter is taken up for hearing. This petition is filed under section 482 of CRPC, read with section 401 of CRPC, seeking quashing of the complaint case being CR number 8213 of 2011, filed by the respondent number 2 before the learned CJM Bongaigaon, corresponding to Dhaligao PS case number 123/2011, registered under section 420 of IPC, and the charge sheet number 60 and the subsequent charge sheet number 69 of 12 dated 27/6/2012, registered under section 417/420 IPC, and the order dated 11/10/2012 passed by the Chief Judicial Magistrate Bongaigaon in GR case number 641 of 2011, taking cognizance of the offense under section 417/420 IPC. Stop. It appears that a complaint case was filed by respondent number 2, alleging that the petitioner received 2 contracts of BGR Oil Refinery and accordingly has subcontracted the said works to the respondent number 2, in respect of which a contract was executed between them on 11/10/2013, and a power of attorney was also given to the respondent number 2 on 17/10/2013. It is alleged that though the respondent number 2 executed the aforesaid 2 works by spending money, however, the petitioner did not open a joint account as per the terms of the contract and instead received running bill in order to misappropriate the same behind the back of the complaint. Accordingly, the complaint case was registered under section 420 IPC. After investigation, the charge sheet was submitted under section
417 and 420.
under section
417 and 420.
417 and 420. Thereafter, the Court of Chief Judicial Magistrate, Bongaigaon, took cognizance by order dated 11/10/2012 against the petitioner under section 417/420 IPC. Stop. Accordingly, the instant criminal petition has been filed for quashing the subject FIR, charge sheet, as well as the entire criminal proceeding. Mr. Chaudhary, learned counsel for the petitioner, submits that on the face of the allegation made out in the complaint, it is manifestly apparent that the dispute essentially is purely a civil one. And hence, continuation of criminal proceeding against the petitioner is wholly unjustified. Stop. Correct? Mr. Borthakur fairly submits that no criminality whatsoever arises out of the allegation set out in the present FIR. Stop. Heard, perused. Apt to reproduce the complaint for ready reference, quote unquote, page 13 to 15. Gute to didiba. It is apparent on reading of the FIR that it is that due to breach of the terms of the contract, the said complaint has been filed. Mere breach of contract cannot give rise to criminal proceeding. The allegation of fraudulent inducement, disappropriation, and deception, and fraudulent misappropriation, intention of misappropriation at the initial stage of the sale, at the initial stage of the transaction, has to be there in order to attract the offenses of section 417 and 420. The essential ingredients of the said sections being absent on the face of the allegation made out in the complaint, the order of the Chief Judicial Magistrate taking cognizance against the petitioner under section 417 and 420 appears to be palpably and manifestly erroneous in law. Accordingly, the FIR charge sheet order of the CJM stands set aside, he is hereby set aside and quashed. The petition stands allowed. But
Item number 14 and 15.
See, my lord, that's, N4. There was an interim order, but that maybe one line.
that would
Interim order was there.
item number
3 and 4 already dismissed, my lord.
3 and 4, that Munir matter. I
Yes,
said that that interim order is absolute. I made it absolute. Or vacated. In item number 3 and 4, interim order, if any, accordingly stands vacated. In item number 3 and 4, he really is Yes, Mr. Fukan?
Yes, please. These are two quashing petitions by the petitioner was handed over a contract for drilling. This was in Sibsagar in the year 2009. Now, we are a company which is really into drilling, seismic zones and everything. And this contract was granted in 2009. Now, in order to execute the contract, we had executed certain agreements with certain local people in order to provide manpower and other assistance that was required to execute the contract. There were certain financial obligations that were there we could not fulfill. In terms of that, there was an MOU executed between all the 5 people whose agreements have been annexed here. Subsequent to that, we could not make the payment. We failed in our financial obligations in terms of the MOU that was executed because there were certain service tax issues that came up. Our bank's accounts were seized. Subsequently, we wrote a letter saying that, listen, I'm not able to comply in terms of the MOU that has been executed. There is an admission of money that needs to be paid on 60 lakhs. But I can't pay. That is committed to be paid within 30th of April 2014. So I need an extension of 1 year's time. And a letter was sent to them. However, on 29th August, in the night, the contractors entered into our premises. There was a certain one vehicle which was repossessed by them in terms of the lieu of the money not being paid, and certain other materials that were lying in regards to a rig work which is already continuing called rig number 51. Now the dues in terms of the MOU is around 60 lakhs. Obviously, it's now I'm not able to ascertain because I did try to get in touch with the company. None of the people are available. Some of them have already retired, and most of the companies got on defunct because it went into NCLT. And the directors are all in jail because of some ED cases. So I couldn't get any much construction information in regards to what is presently happening. But the 60 lakhs apparently is still not being paid, as far as I understand from the facts of this case. The vehicles that has been repossessed are still in their possession of the contractors, the subcontractors, and the amount could not be paid. So I immediately filed an FIR, a complaint first, which culminated into an FIR on the 29th. Now, as a counter to that FIR, they filed another FIR, saying that in terms of my agreement that happened, which is the MOU that was executed between us, you failed to perform your obligation, and therefore, this is the FIR, this has been fraud committed in spite of the fact that money was available. Whereas I have specifically mentioned before that in a letter that this is my financial problem and I have not been able to pay the money because of these reasons. That is how these matters have come into effect. So my FIR is first, subsequently the other FIRs have come into.
Where is the second FIR?
Yes, my lord will first come to the first FIR. That's at page 19.
Yes.
This is FIR number 833. It is on 30th of September 2014.
No, page 20,
19.
page 19,
Yes.
page 19. This is
I'm
dated
sorry, my lord. This is
14.
943, 2014. There are two matters, two quashing petitions. I am taking 943.
Both
I'm sorry.
filed by you.
Yes, both are filed.
There
There were two
FIR.
FIRs filed. Yes. The first in
Which
regards to
one-
the.
Which is the brief that you're?
I am now
doing?
taking 943. I'm sorry, I should have said that in the beginning. I'm sorry.
Look,
There are two, I think the other one is 944. So there were two FIRs that were filed.
Two FIRs, same
Yeah.
FIR.
One in regards to the by 4 people, one a similar allegation by another 2 contractors.
In relation to the same contract.
Same transaction, because all of them had to be paid money.
Yes, 19.
Yes, 19. This is FIR 833, filed on 30th of September. And
This is by the petitioner.
no, this is by the other side. I'm in a quashing against this FIR.
Oh, this is the second FIR.
The FIR filed by the private respondents, with whom I entered into an agreement and I failed to perform the
Correct.
obligation.
So this is the second FIR.
First FIR, there's another one which I'm coming. So 6th of
No, you said you had first filed the FIR.
yes, my FIR. Your lordships are wanting my FIR. That's it at
No,
page.
if I heard you correctly, you said it was you are the company.
I am the company.
So
I
you-
filed the first FIR.
Correct,
Right.
correct. That is what I'm saying.
Oh,
So
I
this
see.
is
The first
second
FIR, my FIR is
No,
at
Mr. Pukan, that is why I'm saying the document FIR at page 19 is the second FIR.
second FIR, but them, not by me. I have only filed one FIR.
Of course.
Yes.
I meant second FIR because what I meant was
Yes.
by them.
Yes.
This is the FIR which you are seeking quashing.
Yes.
Yes, let's read.
Yes. Page 22. Second paragraph.
Is anybody appearing for the other side?
Oh, no, my lord. There are some names reflected, but
Names are shown. All right.
yes. I
Yes,
think Mr. J. Roy's name is reflected, but I don't know.
yes.
Page 22. May I read number 3, paragraph number 3? That Shivani Oil Exploration and
Mr.
Service.
Can you or ask a junior to send the information?
I did try to speak to Mr. Sharma, he's junior, but he said he has no instruction on the matter. So he said, I said I did
About-
inform him.
Okay, then for all right, you
I inform him about it. Paragraph number 3 of that the Shivani Oil and Exploration Services, Sibsagar, had to clear several crores of rupees to the complainant. And for that purpose of clearing such dues, Shivani Oil and Exploration Services, represented by so-and-so, entered into an MOU with the complainants at Noida on 6th and 7th of March 2014. And the said MOU, Shivani undertook to clear the outstanding by 30th of September 2014. And by MOU very clearly agreed and assured that till the outstanding of all the 5 parties, complainants, are not cleared, the operation of rig 50 would be under the sole supervision of the complainants. Till then, the rig number 50 shall not be moved by Shivani. Now, the MOU is enclosed as Annexure A. Subsequent to that, at para 5, in the meantime, ONGC directed Shivani to remove rig number 50 with a threat of levying penal charges. So-and-so, the manager of Sibsagar and Shivani met the complainants with the request to remove rig number 50. The request was made in view of the existing fact that the rig was under direct control and supervision of the complainants. Relevantly, it is as stated in rig number 50 was dehired and was under direct control of the complainants with the authorities. Thereof, the complainant who have got lien over the subject of rig number 50 and with all its accessories until their outstandings are not realized. And as such, they promptly agreed to remove rig number 50 with all its accessories from the ONGC premises.
What does it mean? It's very complicated.
Yes, the equipments that are lying, there are 3 rigs involved here. Rig number 29, rig number 30, 31. So the machineries that are used are normally one machinery, which are used for different rigs to be performed. Now, when I'm entitled for a drilling, I normally take 3 or 4 contracts. I use the same machinery, but particularly I failed in regards to 51, in which these agreements were executed with where I hired the services of these private contractors. So they said, the Oil India had said, if you cannot complete, because I anyway defaulted, I could not complete the project. They said in terms of this, all the equipments that have been taken by ONGC in using by us, because we are the first contractors to do the work, had to be returned back to them because I couldn't complete. They were supposed to perhaps terminate the contract and give it to somebody else. Now, according to them, they had a first right over it because in terms of the agreement to pay money. So in terms, I had to do my job because ONGC said, you have failed, please return the material. So I had to return the material anyway. So according to them, taking that as an advantage, I readily agreed to give the equipments to them because of the term that I failed to perform the obligation. Though I was in an obligation to pay these people by completing the same terms and conditions of that agreement. So that's rig number 51. 29, 30, and 31 were also dehired subsequently. I could not perform any of the contracts at that particular point of time. So to get the transfer challans issued, there was planned to remove rig number 50 and all of its remaining accessories, including the safety of all of them. The removed items are being safely kept in the safeyard of the complainants. So before the ONGC could have a handover, they had already come to my premises and taken away the stuff, which includes one crane, which is worth 1 crore, and some other materials that were lying, which were used for the same work. That the malice designed to deprive the complainants from securing the rig 50 and the accessories, some vested person unauthorizedly lodged a complaint against the complaint. That is my FIR, which is 1 day prior to theirs, where I said that you have come into my premises and taken away all my equipments. Before you, but above noted facts on record are crystal clear, showing that facts that such Ezehar is false, which is
Section has been
my FIR.
no,
Yes.
this FIR.
This is
What section?
yes, my lord. This is 420, 406.
420.
Yes,
And
406.
420, 406.
Yes,
Mr.
and
Bhakur,
complainant has all. This has been registered.
when
In fact, I had just gone
the-
through your lordship's order sometime back. A judgment which has come.
when this-
No element of 420 and 406.
Deception, fraudulent.
Contracts have been signed, money is to be paid. I've admitted my liability also.
It has been, I've been observing so many matters since I've taken up this bench. Cases of 406, and 420 are simply
Nothing. No misappropriation,
registered
no
with
dishonest intention.
ingredients, and these matters
No
are
ingredient.
pending for a long time.
Otherwise, case is pending since long. Regarding the present status of the case, whether in
Present status is not material right now because the FIR on the face of it does not say where
Absolutely,
is
420.
the ingredients.
This possibility that police in this case may also file search without final report. Regarding that only, I will get the instruction.
There was no stay.
There was a stay, my lord. I mean, yes, there is. I have that order. It is 26/11/2014.
Then it's already stayed.
833 has been stayed. And interestingly, our FIR, which is prior to their coming, they have not come and questioned anything or nothing has happened in that.
What
In-
is this FIR? They simply had filed. Looks like it's a counter FIR. to
That is what
the
exactly the case
FIR
is.
that
I
they
was just coming to
filed.
that.
And there is no allegation of cheating. Where are the ingredients? Show me. Where are the ingredients? How 420 and 406 could have been put against the petitioner on basis of such averments? He simply says that they want to, he himself, the complainant agrees in view of her crystal clear showing the fact that such Ezahar is false, lodged with malice design to harass the complainant. Then he should have gone for quashing.
Not come
He has not gone for quashing.
till date.
On the contrary, looks like this has been done with a malified intention. The absolute abuse of the court process.
Your Lordship says, in fact, held in a very similar case, which I have in my hand, Bajender Das.
Please give me that stay order is off.
Yes,
On 26/11/2014.
in both the matters, there is a stay. Both the cases. I think it's the same FIR.
You have the orders.
Yes, 26/11/2014. I'll just give you a Lordship. 26/11/2014. This is in relation to case number 943.
Yes. I'll dictate it at in 5 minutes. I'm
Yes,
just resuming in
great.
5
Yes.
Mr. Pukan, please find out if the FIR dates and the same FIR or different two FIRs.
Yes,
The
I'll just find-
information, just
Yes, I'll just give
please
it.
ask your junior to
I'll just give it to
to
you.
me in a piece of paper.
I'll just give you a Lordship, just now. Second, if I can get to proceed, that to vote. আমার কাছে over 38 এখন হচ্ছে 833 আর এখন হচ্ছে 123. One more of case. Yeah, what was the company to wound up was Delhi High Court. Oh, Delhi Rescue Story. এটা পছন্দ করেছেন এইটু তা হচ্ছে CRP 944 CRL petition 940 with me it's the same matter. Would your lordship be kind enough to take 93043 because all the
No, no, that's all right, but I just wanted to see this. FIR.
the two FIRs which they have filed is one is 123 of 2014 and the other one is 833.
No,
One
I
is
think this
30th
is
9, 610.
6/10/14.
Yes, that is 128 of 2014. And the 30th 9,
What is 128 means?
that's the other FIR which has been filed. Same context. Two FIRs have been filed.
Mr. Fukan, you've confused me. The 6/10/14 is the FIR which is sought to be quashed in
Both the
criminal
FIRs have to
petition.
be quashed, both.
I understand, but in criminal petition 944 of 2014, it is the 6/10/14.
Yes, yes. The other one is this.
All right. না তোমার দুটা জাজমেন্ট সেপারেট কে বললাম হ্যাঁ সেকেন্ডটোত খালি এই এফআইআর ডেট আর কন্টেন্টস টু চেঞ্জ হয়ে যাবে the rest everything will remain the same. Petitioners are different. Sorry, the complainants are different.
There are 5 in total. They have related to the same incident, but filed in different modes. That's it. We also have filed 2, one in regards to the repossession of that vehicle, and the other is in taking away possession from us the material.
Heard Mr. R.B. Fukan, learned counsel, appearing for the petitioner. Also heard Mr. T. Borthakur, learned APP, for the state respondent. None appears for the respondent on call, respondent number 2 stroke complainant on call, despite the names of the learned counsels appearing for the respondent number 2 being reflected in the cause list. These respondent 2, 3, 4 are same in the other one, or they are different?
Yes, same.
3 different.
3,
same.
yes, same.
Why 2 FIRs then?
Because one relates to the taking away of the agreement that was only executed 4 people. The other agreement in which they're saying that we owe the money is regards to the other 3 complainants. So money is due to all of them. They have filed 2 different. That both the FIRs are in 943 are in 19
Okay.
and 27 page.
All right,
both.
you just hear me out.
Yes.
This petition is filed under section 482, read with section 397 and section 401 of CRPC 1973, seeking quashing of the FIR registered under Sibsagar PS case number 833 of 2014. FIR dated FIR dated 30/9/2014, huh?
Yes.
Registered under Sibsagar PS case number 833 of 14 under sections 420, 406, 34 of IPC, pending before the officer in charge, Sibsagar Police Station, Sibsagar. Stop. The brief facts of the case is that the respondent numbers 2, 3, and 4 filed a FIR on 30/9/2014 before the jurisdictional police station, alleging inter alia that the petitioner number 1 has outstanding dues amounting several crores of rupees to the respondents in respect of work executed by them pertaining to drilling rigs 29, 30, 31, and 50 of the Oil and Natural Gas Company, hereinafter referred to as ONGC, under the principal contractor, i.e., no, is this the company? Under the petitioner number 1. Under the principal contractor, i.e. petitioner number 1. For the purpose, continuation, for the purpose of clearing such dues, no, stop. It is further alleged that for the purpose of clearing such dues, an MOU, Memorandum of Understanding, was entered between petitioner number 1, represented by petitioner number 2, 3, and 4, and the and the private respondents on 6/3/2014 and 7/3/2014. However, the petitioners failed to clear the outstanding dues despite repeated requests made by the private respondents from time to time. It is further alleged that accordingly, the said FIR was registered under section 420, 406, 34 of IPC. Stop. Situated thus, the present petition has been filed for seeking quashing of the said FIR. Stop. Mr. A.B. Phukan, learned counsel for the petitioner, submits that in fact, prior to filing the instant FIR, the private respondents forcibly with their muscle and money power removed the valuable equipments of petitioner number 1's rig 50, which is presently in the custody of the private respondents, for which the petitioner number 1 lodged an FIR on 6/10/2014. I'm sorry. Page? No, in the, where is it mentioned here? One second. Thereafter complaint was lodged, for which a complaint was lodged by the petitioner number 1 on 29 20 or 29 29/9/2014 against the private respondents, against the action of the private respondents in illegally removing the valuable equipments of rig 40. He further submits that as a counterblast and to harass the petitioners, the instant FIR has been lodged by the private respondents. He further submits that even assuming the allegation made out in the FIR to be correct, no criminal case whatsoever is made out against the petitioners. He further submits that at best, it is purely civil in nature. He therefore submits that continuation of the FIR, continuation of the criminal proceeding. He further submits that the FIR accordingly is erroneous and is liable to be set aside and quashed by this court. Correct? These are your submissions. Per contra, Mr. So-and-so Borthakur, learned APP, strongly opposes the prayer of the petitioner seeking quashing of the FIR in question. He submits that that investigation is yet to start, and therefore this court ought not quash the instant FIR. Right? I have given my prudent consideration to the learned arguments, to the arguments made by the learned counsels appearing for the contending parties, and have perused the materials available on record. It appears that the petitioner number 1 entered into 4 contracts with different parties for the man management and relevant services for operation and maintenance of drilling rig at Sibsagar. And the 4 parties with whom the petitioner number 1 entered, with whom the petitioner number entered into the said contracts are A, B, C, D at page 7. It appears that the petitioner number 1 had been awarded a contract for drilling services in the state of Assam by the ONGC, for which purpose the petitioner number 1 required the services of man management and relevant services on fixed per day rate stroke charges. Accordingly, the petitioner number 1 entered into contract with the aforesaid companies via 4 different contracts. Pertinent that there is an arbitration clause wherein arbitration clause for resolving dispute between parties is also is there. Stop. It appears that though the petitioner number 1 was initially performing its obligation under the terms and obligation stipulated in the 4 contracts in question, however, in the last phase of work, dispute arose between the parties as regard the due owed by the petitioner number 1 to them. In respect of the said dispute, an understanding was reached between the petitioner number 1 and the 4 companies as regards the payment obligation of petitioner number 1 in respect of the outstanding dues, and accordingly a memorandum of understanding was entered between them. It appears that in the memorandum of understanding, on behalf of the petitioner number 1, the petitioner number 1 was represented by the petitioner number 2, 3, and 4. It appears that despite the aforesaid understanding, the petitioner number 1 could not pay the said amount due to severe financial crisis on account of embargo imposed by the Service Tax Department. It appears that the Service Tax Department has directed the clients of the petitioner number 1 company not to release any payment to the petitioner number one company, for which the petitioner number one company is in financial crisis. Stop. It further appears that the petitioner number one, by letter dated 13/8/2014, intimated the said four companies as regards the same. It was further informed in the said letter that the petitioner number one would be in a position to clear its dues after 6 months or so from the date the said embargo is from the date the service tax department lifts the said embargo. It further appears that the petitioner number one proposed to clear the outstanding dues by way of monthly installment over a period commencing from August 2014 till March 2016. Paragraph 10, some typo error. Paragraph 10. Paragraph 10, I think some typo error is there. Please check. It appears that the respondent forcefully and illegally enter it appears that thereafter the private respondents forcefully and illegally entered the Godam of the petitioner number one company and unlawfully took away the valuable equipments of Rig 50, which belonged to the petitioner number one company. Accordingly, the petitioner number one lodged two FIRs, being FIR number 123 of 14, dated 29/9/2014, before PS Moranhat, and FIR number 830 of 2014, dated 29/9/2014, before PS Sipsagar. Apt to reproduce, where do I find these two FIRs? Apt to reproduce the relevant portion of the aforesaid two FIR for ready reference. Page. Page 157, A to A, huh? And to quote unquote করে দিবা আৰু 162 A to A. It appears that pursuant to the aforesaid two FIRs filed by the petitioner number one against the private respondent, the private respondent filed the instant FIR against the petitioner, against the petitioners. Yes? Against the petitioners. Apt to reproduce the said FIR dated 6/10/2014, which is hereunder. Quote unquote, page. I think it starts at 22, isn't it?
September and 6/10 are their FIRs. 29th September is our.
That's done. I have covered it. Your FIR I've covered. Now their FIR, they have also filed 2 FIR.
Yes.
But the FIR that you're seeking quashing is the one at 22,
Otherwise, the other.
is a 22 page.
Yes. That is the first FIR.
That is what you are seeking quashing in this petition. And the other,
Six.
correct.
It's 940.
So that we are going to deal it together. Page 22, A to A. A to A. Yes, which is the other one?
6/10.
6/10 I have covered. Then,
Page 90. The work is already covered.
no, why?
This matter.
Yes, why is of this matter? It is,
943 is related.
sorry, I stand corrected. This is 39, 39/14. Some confusion with the dates. এইটো ওপৰতে মই যেতিয়া quashing date to কৈছিলো 39 কৈছো না? Okay. এতিয়া তলৰ তুমি 39 is the FIR which you are seeking quashing, right? 39. Yes, 39. Page 22, A to A. And which is the other page you were drawing my attention to?
Yes. Page 7. Same private complaints. Same issue.
This is the next case.
Next.
Pertinent that the complainant that the private respondents has also filed another FIR being FIR number 128 of 14 dated 6/10/14 against the petitioners, which is registered under section 420/406 IPC. Against which the petitioners has filed a separate quashing petition being criminal petition number 944 of 2014. Stop. Parent reading of the aforesaid FIR that no allegation as regards fraudulent inducement or deception is made out in the body of the FIR. Further, it is settled law that it appears that there has been breach of the terms and condition. There has been breach of terms and condition of the MOU in question, for which at best a civil action could have been brought against the petitioner. Every breach of trust, every breach of contract does not give a rise to a criminal proceeding. It is well settled that an act of breach of trust, it is well settled that every act of breach of trust may not result in penal offense of criminal breach of trust unless there is evidence of manipulating act of fraudulent misappropriation. In the instant case, there is no such allegation discernible from the body of the FIR. On the contrary, it appears that the private respondents are using the police stations and criminal courts as forums to settle a civil dispute. Stop. Hence, it is nothing but clear abuse of process of law to prevent the petitioners from proceeding to take appropriate legal action against the opposite parties. FIR, therefore, I am of the unhesitant view that the FIR is that the present FIR is nothing but clear abuse of the process of law. Hence, continuation of further proceeding in respect of the said FIR is totally, it would amount to gross travesty of justice. Stop. That being so, the FIR dated 30/9/2014, FIR number 833, dated 30/9/2014, registered under Sibsagar PS case number 833 of 2014, under section 420, 406, 34 IPC, stands set aside and quashed. That's all, nothing else. Interim order passed earlier accordingly stands absolute. Is hereby made absolute. Criminal petition stands allowed. Second criminal, it to be agote koriloba. Second not a body to didiba. FIR date to change over. FIR number would become 128 of 2014 and date will be 6/10/2014. The rest, everything will remain same. Aru in that last paragraph of Kobat Mo Kusuna, Aru ekhon FIR file korsile, heitut interchange hoy jabe. I'm going to edit it. So I'll look into it. It main to trade option into the decision to tolerate trade. This is item 14/15. All right.
Item 16.
Wait, both is palace. I see now what it was. Yes. They're not appearing. No, but last occasion they were there. Hmm? Like it's not mentioned as requested 4 weeks. Taking time and not appearing are two different things, Ms. Fukan. That is different. None appears for the petitioner on call, MS K. K Fukan. MS K Fukan, Learned Counsel is present for the respondent. In view of the non-appearance of the Learned Counsel appearing for the petitioner, relist this matter, relist on next week at the in the order column with the remark for dismissal.
And 18.
Yes.
Now, this is 10/7/2019, the first step. Is there a particular case is number 11514? Next is also the 119. And almost it was 619.
You don't have the case diary. All right, you have it. Heard Mr. L. Mohan, Learned Counsel for the petitioner, also heard Mr. K.K. Parashar, Learned APP for the state respondent. Mr. Parashar submits that the case diary call for is not available with him today and accordingly seeks accommodation in the matter. List after 2 weeks did you on such and such date to enable Mr. So and so to place the case diary before this court on the next date of listing.
Item 19.
Yes.
Pursuant to the completion of the investigation, I was logged under section 7 of the Essential Commodity Act, 403 of the IPC and 120B. So after the completion of the investigation, a charge sheet was filed. Pursuant thereto, the trial commenced before the Learned Chief Judicial Magistrate, Origa. The Learned Chief Judicial Magistrate, after securing the attendance of us, proceeded to frame charges. All these documents are annexed. Thereafter, two prosecution witnesses were also examined. But thereafter, what the Learned Judicial Magistrate does is, as per the provisions of section 12 capital A, 2 capital S of the Essential Commodities Act, the matter was committed to the special judge. Because it says all offences under the Essential Commodities Act is to be tried by the special court. So the matter was committed to the special court. So thereafter, the special court again proceeded to take the matter. So I appeared before the special court. Thereafter, charges were fixed and the cases were fixed.
Slow.
Sorry. Thereafter, cases were fixed for evidence. But what happened, person therefore recently informed. Again, now the cases are transferred back to the CJ.
Okay.
CJ, and so the special court is not proceeding with the trial now. The CJ is seized of the matters.
CJM is proceeding.
Yes, CJ is.
Then what is to be done? So up to date scan copies.
Also is
No, that you find out,
okay, I will try, but if you're not.
Mr. Bhattakur. Call for. So yes. Yes. It was transferred back. That he has to find out.
It is going on in the
No, you find out then how it has gone back to CJM court.
Section 12 AA of the essential commodity tax. Chief Judicial Magistrate or an SDM is not the authority.
That's right. So these are, let's have the scanned copy of the. No, it is, no, 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 no. No, not like this. Mr. MP Chaudhary, Learned Counsel for the petitioner, submits that submits that in the meantime, the proceedings have been transferred to is transferred back to the SDJM Morigaon Sodor for adjudication. In relation to GR case number 507 of 2000. Stop. He accordingly submits that submits that the up-to-date scanned copy of the case records is essential. Case records along with present status report be called for. He will don't say he, it is submitted at the bar because both are jointly submitted. We call for. Let registry call for the scanned copy of the case records along with the present status of the case from the court of SDJM Morigaon Sodor. Relist. They did your after Bihu.
Item 20.
For hearing. Yes, Mr. Locker. Green. Pink. Green. 19-2, yes. One second. What is this order at page 39? You are challenging this order and you are the complainant or you are the complainant? No, but just I want to have a grip of what is under challenge. What is what by this order, what has been accepted? Because it says prayer in petition is accepted. Yes. By which order this was rejected? Which is the order that rejected? Mr. Counsel, I'm asking a very simple question. By which order this recalling application filed by you has been rejected? Three? Where do you get that? Yes. 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 Page? Yes. Please read.
concerned that the complainant had underestimated earlier in the delegation, even the expression number one, preventing the witness termination draft or maintaining before the court and enriching the evidence and by offering monetary immunity. This court seriously, this court is serious now of the immunity and direct complainant. The provisions witness and to verify the authenticity of the case. However, this court had not taken any such evidence from photograph again. The state has become presumptive. As said earlier, the complainant Q150 is yet to be disposed of by this court. That was a long time back.
All right, continue.
I believe the victim has gone through the defense department general. I have also worked on other companies. The Indian country completed written arguments in furtherance of the in the application. As stated earlier, complaint of this case, petition number 3150 that has an to meet started serious allegations against the accused persons of the case. The complainant had alleged that two accused persons had unlawfully tried to hamper and tamper the prosecution arrangements by putting witnesses and issuing facts to the witness. The complainant, as expected, this court seriously of the matter and order the personal appearance of the accused person in spite of the fact that they are under accusation of the Indian country. This court also directed the complainant to produce witness so that they can put their demands to the court. If any against the accused person, in pursuance to order it to 18, the accused person will be appeared before the court and vehemently denied each and every evidence of the complainant. Thereafter, on being satisfied with the assurance of the person, please put rejected from the other person. They have on being satisfied with the assurance, giving accuracy, admitting their guilt. But how can that be rejected?
No, wait. Your recalling application is this 3150, right?
But there are
No, just answer the query. I'm getting what you're saying. That application 3150 is that order, correct? Now it says that it was rejected on 19/2/18. 19/2/18, there is no rejection. Well, 19/2/18. It says hence prayer in petition is accepted. No, where have the Leonard Court has said, oh, this petition 3150 is hereby rejected. Hereby rejected. So now you are challenging which order? 19/2/18. Where? Let's see a prayer. Yes, 19/2/18 he's challenging.
By which the also statement is taken, date order has been surrendered. 13, 12, 18 order has been surrendered.
No, here.
Of this order was 1980. There was no any revision petition. Thereafter, there was
I'm on your prayer. After the parties to be pleased to set aside the impugned judgment and order dated 27/6/19. Which page is this order? 13? 27/6/19. Which page? Because that is the judgment which is under challenge. Where is that judgment? Page 51. Yes, please read. No, not everything. Come to the operating part. 56. Para 7, 56.
Stating that the accused so for reducing evidence in the case by offering bribes in the witness on 10 and 16. And another witness participated also because to reason because of what alleged there might be an involvement of the accused in the case. The petitioner
Therefore, faith to ensure the fact that corruption evidences of corruption evidences and not for the both the accordingly, the learned court directed the ethics person to ensure particular on the main after hearing of the and also after being heard to accuse that the learned counsel rejected the petition, so the administration was the president of the complaint. Learned counsel for the petitioner again after but another petition for recording the witnesses learned trial for consequences on further evidence of the complaint. Thereafter, on 21 June 15 and 26 the case was put for further evidence that the complaint did not evidence unless the proceedings and evidence was proved and fixed for defense. It is not correct. My minor computer has not proved the evidence. I was absent to prove my lord, but learned computer had to pass a written order as to why I was not my fear was not allowed. On 13/12/18, the learned trial court passed out as follows. 13/12/18, the complainant is asking his case back to the on the ground and the take up in there. After having the opposite apart from the defense, the person statement of defense duly recorded. My lord, the learned court will accidentally not compare finding that statement is taking the defense of the I will be allowed to further my account is being further.
But you have to show what is the error. Mechanically, this court cannot allow this application. It appears that some two persons had given evidence that they have not been threatened. That is there. That is there. It seems two persons have been examined by the trial court, and they have said they have not been threatened by the accused. All right, we'll have it on another date. It is already 1 o'clock. We'll have it on another day. Relist after 2 weeks of the date. Interim, if any, may continue to the next date of, shall continue till the next date of listing. Yes, that's wrong me. Sorry, I can't hear you. Where is the complaint? Mr. Chaudhary, you are for the husband. Yes. Yes, please read. You are for the wife. Mr. Chaudhary, she had come with the police to take her Sridhan. And all right, I shall resume at 2.